We're now going to open up our next public hearing, which is on House Bill 3047A. Michael, I understand you're the lead. Could you give us the overview?
I am, Chair. Chair Prozanski, members of the committee, House Bill 3047A comes to you from the House on a 58-0 vote. It creates a civil cause of action for the improper disclosure of certain personal information, such as personal phone numbers, email addresses, and home addresses, also known as doxing. In order to bring a claim, the person must prove that their information was knowingly and without consent disclosed with the intent that they be stalked, harassed, or injured, and that a reasonable person would have been so harmed in similar circumstances. There is an emergency clause on the bill and a minimal fiscal impact and no revenue impact on the underlying bill. There are also -A5 amendments before you today from the League of Oregon Cities. Those amendments seek to clarify when certain public employee personal information is exempt from a public records request. And I believe Scott Winkles is here to discuss that amendment with you as well.
All right. So at this point, what I'm going to do is I have a number of individuals who are scheduled to give testimony. We are working off the 2-minute time frame at this point. What I do want to do is allow for, I believe we have 3 members that are scheduled to give testimony. I'm asking the members to please be as brief as you can so we can make certain that we get as many people to testify that have signed up to also give oral testimony. So the individuals I have in the way of representatives, I have Representative Bynum, Representative Witt, and Representative Post. We'll go in that order if that's okay. So Representative Bynum first.
Good morning, Chair Prozanski. I don't intend to testify on this bill, so I'll yield my time. Thank you.
All right, thank you. Representative Witt.
Thank you, Mr. Chairman and members of the committee. Good morning. I'm State Representative Brad Witt from Oregon's House District 31, appearing before you in support of House Bill 3047 this morning. I think most all of us appreciate and value our personal privacy, but doxing, which is cyberbullying, takes our privacy away. I have been a target of doxing, as have the members of my staff, and that's what prompted this bill. And following its passage off of the House floor, I was doxed once again as a demonstration of in your face, this is what we can and will do to you if you continue to pursue restraints on our ability to dox. Doxing is not just the publication of personal information. It's actually an invitation to the general public to create harassment and mischief. And it not only happens just to politicians, it has happened to law enforcement officials in my home county, to court employees, to women and minorities. And in an effort, Mr. Chairman and members of the committee, to prevent this from continuing to occur, as it has once again to myself, I urge your favorable passage on House Bill 3047. Thank you very much for this opportunity.
All right, thank you, Representative. I have Representative Post next.
Thank you, Chair Prozanski, members of the committee. For the record, Bill Post, House District 25, St. Paul, Kaiser, and Newburgh. Michael, if we could pull that up, I think rather than talking much, I'd really just as soon show the pictures. Let me just give you a quick background. All of us, as elected officials, have certain information that is very public. A search of OLIS and ORSTAR and whatnot, that's public information. But our private information, such as our a home phone number perhaps, or our staff's phone numbers, but especially our social security number, our bank account numbers, our credit card numbers. In 2018, I was the victim of a national journalist who decided to teach me a lesson, so to speak, which you can see right in front of you. That was the warning shot. We didn't get screenshots of everything that he did, But go ahead, Michael, to the next one. That's public information right there. As you can see, there's my home address, but there's a picture of my house. Now, again, that's public information, but you can see that we're gearing up towards something. Go to the next one, Michael. And you can see here, he says, it took me 25 seconds to get all the information about you, your wife, your son. By the way, tell him happy 25th, your neighbors, etc. And I would add to that before you move on. Actually, move on to the next one because it actually repeats. And now go to the last one. Not only was my phone number given out, my social security number, my bank accounts, my credit card, my wife's phone number, my son's phone number, my staff's phone number, our home phone was hacked into our Comcast voice over internet. All of this happened and over the course of about 4 months. In 2018, I am still paying for it. I just had another credit card opened in my name in Atlanta, Georgia, 2 weeks ago that I had to deal with. And as you can see right here, this is a national journalist. He says, now that I've demonstrated to you that I can get your home address, personal phone number, social security number, I have deleted it, which he did. He posted it. And by the way, he had about 2 million followers on Twitter that this went out to. So I don't think you can even imagine how massive the scale was on this. And then he says, that he's going to do it again if he wanted to. So, and that's all the pictures that I have. So members of the committee, this bill passed unopposed in the House. This is what doxing is. I'm a public figure. There's public information that's easily gotten by anybody, but my social security number and all the other things, that's not something that can be just given out over the internet. I have read the -A5 amendment. I am not in favor of it. It has nothing to do with this bill, and I do not believe it would have passed the House, this -A5 amendment. I will not be supportive of it, and I would urge you not to pass it. This bill has broad bipartisan support as is, because this doxing issue needs to be taken care of, and Oregon needs to be a leader in it. Thank you, Chair Przonski and members of the committee for your time.
All right, thank you. Our next group of people or speakers that are on a panel is Kimberly McCullough, Aaron Knott, and Matthew Call. So Kimberly first.
Thank you, Senator Przonski, members of the committee. My name is Kimberly McCullough. I'm the Legislative Director for the Oregon Department of Justice. I will be extremely short today. Just want to mention that we appreciate the thoughtful approach that Representative Bynum and the work group members that developed this bill took. We worked very carefully to navigate the free speech protections of the First Amendment and Article 1, Section 8. I have submitted some written testimony that discusses some of the amendments that we worked on in the House to tighten up the language and make it very clear that this bill is aimed at disclosures which are made with the intent to harm. And we clarified that type of harm, which is to stalk, harass, or injure, and then included some more clarifying definitions of those terms. And I want to just note very briefly, and I have mentioned this in my written testimony as well, that this is distinguishable from disclosures that are made to comply with a legal obligation or which occur in the normal course of business under federal or state law. And then just briefly regarding the A5 amendment, we really think that that is a separate issue and would appreciate having that conversation in the Public Records Advisory Council. So thank you.
All right, thank you. Aaron?
And good morning, Chair Przonski, members of the committee. For the record, my name is Aaron Knott. I'm the Policy Director for the Multnomah County District Attorney's Office, and I'm here in support of 3047. I was initially neutral on this concept and involved just to help with technical questions around freedom of speech, similar to what Ms. McCullough just testified to. But after hearing story after story of prosecutors at my office having been doxxed, we ultimately moved to supportive. These are cases where their pictures of their house will show up on the internet with a caption that says, "We know where your kids are, do you?" And it's not just prosecutors that are getting this. It's defense attorneys, it's probation officers, it's DHS caseworkers, it's political activists across the entirety of the political spectrum. Just to make a brief technical record, somewhat coming off of what Ms. McCullough just testified to a moment ago, this the cause of action in 3047 is written very, very narrowly, and it has to be to survive a challenge under Article 1, Section 8 of the Oregon Constitution. So I just want to refer on the record for the sake of legislative history to that test, which is State v. Robertson. It's been the test for freedom of speech in Oregon for 30 years, and it requires that you intend a constitutionally recognized harm, like stalking, injuring, or harassing somebody, that harm actually result and that the experience of that harm be reasonable. And the reason I want to flag that here is that element of intent. Just putting somebody's personal information on the internet is not going to trigger liability. It really does have to be done with an element of malicious intent. Representative Post gave out a good example. The kind of context where you can say, just from the nature of the posting, the intent here is harm. It's not to collect a debt. It's not to do business. It's not to collect taxes. It's to hurt somebody. And that's a distinction drawn by the bill and also drawn by the Constitution. So I just want to make that point for the record, and I'm open for, I should also note, we are neutral on the A5 amendments, but I'll stick around if there are questions on those as well. Thank you.
All right, let's take Matthew Call next. Matthew, you with us? *6 if you're by phone.
All right, thank you. Good morning, Chair.
Good morning.
My name is Matthew Call. I serve as the Vice Chair for the Anti-Defamation League Pacific Northwest Regions Advisory Board, and I'm a resident of Lake Oswego, Oregon. On behalf of the ADL Pacific Northwest, I appreciate the opportunity to speak to you this morning in support of Oregon House Bill 3047. Founded in 1913, ADL has had a timeless mission to stop the defamation of the Jewish people and to secure justice and fair treatment for all. Our work in ensuring the protection of marginalized communities, both online and in the real world, is more relevant today than ever before. Unfortunately, we know that hate and extremism are on the rise, and digital spaces are not immune. According to a 2021 nationally representative ADL survey, 41% of Americans have experienced online hate and harassment, and 27% have experienced severe online harassment, including sexual harassment, stalking, physical threats, swatting, doxing, and sustained harassment. Online hate continues to ruin lives by stoking fear, silencing voices, and causing harm to people's physical and professional safety. One of the most common tactics of online harassment is doxing. These actions are a severe threat to our community, particularly individuals of protected classes, affecting the ability of already marginalized communities to be safe in both digital and physical spaces. Unfortunately, our laws have not kept up with hate and harassment online. The penalties for such offenses may take into consideration the serious and lasting effects of online hate and harassment. Doxing must be codified into Oregon state law so we can protect targets and hold perpetrators accountable for their malicious and reckless actions. As we have worked on this issue with other state legislators across the country, we are pleased to have worked with the Oregon Department of Justice and the Multnomah County Prosecutor's Office to ensure that the language in this bill meets the rigorous standards of the state's constitution. Through careful consideration, we believe the current language as proposed is a careful balance that not only addresses the threat of doxing, but also protects our First Amendment rights. We thank you for your support and look forward to any questions you may have.
All right, thank you. Our next speaker is going to be, to get down here, Jason Myers.
Good morning, Chair Przansky, members of the committee. For the record, my name is Jason Myers. I am the Executive Director of the Oregon State Sheriff's Association, and I'm testifying on behalf of the Sheriff's Association and the Oregon Association Chiefs of Police. I'll keep my remarks very short and succinct. I'd just like to begin by thanking Chair Bynum for establishing a work group this past summer. As you heard today, and we heard on the work group, in the work group setting, that doxing knows no bounds. It attacks individuals from law enforcement to elected officials to individuals who are booked into jail. Just in the past year, there's been a number of significant incidents and a rise in incidents involving law enforcement individuals that have had their information posted or live streamed while they were working, their home addresses and such. There also was a very large amount of personal information that was released nationwide, including Oregon public safety professionals It was so large in breadth that the FBI provided a bulletin warning public safety professionals across the nation. We fully support this measure and ask for your support. We have not had a chance to review the A5s, so we're not in the position to share a position with that today. Thank you for this opportunity to testify.
All right, thank you. Senator Thatcher, you have a question?
No, I just noticed I left my hand up, sorry.
All right, thank you. Our next speaker is going to be Courtney Graham.
Thank you, Chair Przonski, Vice Chair Thatcher, members of the committee. For the record, my name is Courtney Graham, and I'm here today on behalf of SEIU Local 503 in support of House Bill 3047. I'm here today because we believe that no one should be subject to doxing generally, including public workers like the folks that we represent who serve our state and who are attacked in this way simply for doing their job. Before I begin, I want to acknowledge that this past year has been difficult for all Oregonians, including business owners and folks they employ who have been impacted by the measures our state took to keep people safe from COVID-19. At the same time, I've been made aware of a growing and concerning issue related to COVID-19 and workplace safety. SEIU Local 503 represents the workers at Oregon OSHA who inspect and support employers who have received complaints or citations for violating workplace safety rules and regulations. These folks, even during the pandemic, have continued to show up to do their jobs. And I believe some of them are here today to testify because unfortunately they have begun to be subjected to threats and intimidation tactics such as doxing for doing their job. When doing inspections in the field, the folks we represent have been faced with incredibly concerning and unsafe situations. They've been threatened with firearms and other weapons by business owners and members of the public who intend to intimidate them from completing their inspections. They've been approached by large groups of individuals outside of businesses upon arrival. And of particular relevance here, at least one staff person at OSHA has had their name, personal information, address, and private information about their wife and children posted online with encouragement to others to harass and intimidate them. I don't intend to make this about COVID-19 safety rules or other issues. That's not the subject of this bill. However, it should not be acceptable for any worker, including a public worker, to be threatened and intimidated in the course of doing their job. Our hope is that by creating a right of action against the people who engage in this doxing behavior, regardless of who the target is, it will deter this behavior in the future and give those who have been impacted an opportunity to have some kind of redress. The last thing I'll say is that issues related to doxing and the availability of personal private information is a particular issue for public workers. Because of the way PII for these workers is treated, their information is more likely to be publicly available because it is subject to public record. This issue is intertwined with this bill due to the fact that by virtue of being a public employee, certain personal information is subject to public release. And I'll just close by saying this is why we support the -A5 amendment, and we hope the committee moves to adopt it. And I want to thank you for your time and the opportunity to testify.
All right, thank you. Our next speaker is Grace Helland. Excuse me.
Yes, I'm here.
All right, Grace.
For the record, my name is Grace Helland, and I live in Lebanon, Oregon. Chair and members of the committee, thank you for this opportunity to testify in support of House Bill 3047. I work part-time for a nonprofit organization as a paralegal, and I am also certified as a personal support worker for my young disabled cousin. Doxing is essentially an easy way for people and organizations to work outside of our judicial system to try to shut down and punish people who believe differently than they do. It's done with no regard to the rights, age, or safety of other people. I've worked with a nonprofit organization called the Freedom Foundation for a while now, due to being passionate about our constitutional rights. I have particular interest in constitutional rights related to public sector workers' rights concerning their union because I, as a PSW, am required to be represented by SEIU 503, and my father was required to be represented while he worked for the state. Additionally, due to my position as a PSW and several other experiences, such as having worked in a high school cafeteria, I know many other public workers and caregivers. I love speaking with public employees and informing them of their rights and their Constitution and giving them resources to take advantage of those rights and defend them if necessary. Because of my work at the Freedom Foundation to inform people of their rights, I was doxxed on a website called freedomfoundationscanvassers.com, which was a project of another website supported by several unions and run by a blogger named Peter Styczynski. He posted my home address and birth date, in addition to posting pictures, home addresses, and birth dates of fellow caregivers who were working with me at the time. I was still a teenager when this happened. Thankfully, this website was recently taken down, but doxing reduces real, unique, passionate people who truly want to make the world a better place to whatever stereotypical ideology the doxing party decides to label them as, and malicious attempts to harass and drown out their voice. Sometimes it's even an organized effort, as in my case. This is why I'm glad to support House Bill 3047 and urge the committee to vote yes. Thank you.
All right, Grace, thank you. Rebecca Gladstone.
Hello, Chair Przanski. Thank you for taking this testimony, and members of the committee, thank you. I'm speaking, this is for the record, my name is Rebecca Gladstone. I'm speaking on behalf of the League of Women Voters of Oregon. The League supports this bill, and I encourage you to look at our 2020 Privacy and Cybersecurity Today study and position adopted this January. Several concepts are relevant. Our positions support this, and they're in the testimony on the record. Our League study showed that evolving technologies challenge common privacy assumptions. Most people, until recently, would assume that the kinds of personal information listed in this bill would be private, but a quick online search can readily reveal much of this, and online information can persist for a very long time. Importantly, this bill excludes taking legal action for exposure found in a casual search by requiring the establishment of intent to stalk, harass, or injure. For example, we call your attention to Oregon candidate filing information publicly listed in ORSTAR without malicious intent. Home address and both work and home telephone numbers are required for filing to determine jurisdictions and facilitate certification. Public disclosure of these, however, is not necessary, as we recommend in House Bill 3393, which the League also supports. It recommends including these revisions in upcoming election software updates. League positions recommend protecting this sort of private information consistently. As a state, we need to address the heightened risks of personal information exposure by 21st century technologies and commit to high standards for personal information use, meaningful information protection, and appropriate measures to limit potential harms. That applies to those participating in lawful protests, those running for public office, and anyone who might be subject to malicious doxing. Anticipating that governments at all levels around the globe will soon be addressing, I'm almost done, information and communication technology policy, the time is right for Oregon to review and strengthen its data responsibilities, from privacy rights to public information transparency to providing consequences for infractions. Thank you for the opportunity to discuss this legislation.
All right, thank you. Alan Kessler.
Good morning, Chair, Vice Chair, members of the committee. My name is Alan Kessler. I use he, him pronouns. I'm an attorney in Portland. I largely practice public records. I'm being sued by the city of Portland right now by Scott Winkle's client because I want some metadata on communications occurring on public employee official phones. When I requested this information, the city of Portland wrongly used the language that the exemption that's being changed in Amendment A5 to require that I pay $100,000 for some communications metadata. The district attorney agreed that that was nonsense, ordered disclosure, and now the city has sued me to prevent that disclosure. Rather than litigate this, the city and the union have pushed in this last-minute amendment that would gut the public records law. What this does is it treats every single public record as though it were in a personnel file. So every single record, if you go to the county recorder's office and ask for a deed to a house, the county recorder will now need to look and see whether any of the public employees in that office own that house, and if so, redact the address on that deed. If you ask for any record at all, now the public body will be able to charge the public for the review and redaction time and delay disclosure to see if there are any physical addresses or any phone numbers. And if so, redact those. There's a reason that the word personnel is in the language. The word personnel is being struck in Amendment A5 is in there. It's to make sure that not every single record gets treated like a personnel file. This is a massive change to the public records law that was pushed in very little public knowledge. It should go to the PRAC. It should go to the Public Records Advisory Committee. If it's going to move forward at all, it should not be slipped in as a last-minute amendment to gut access to the public records law.
All right, thank you. Phil Jensen. Phil, I think I hear you coming in. Phil Jensen.
Thank you. My apologies, sir. Thank you, Chair Przansky and the other members of the committee. My name is Phil Jensen. I'm a Senior Safety Compliance Officer with Oregon OSHA out of our Bend field office. I was asked to speak today on behalf of a coworker and many of my coworkers, but particularly one that on April 18th was doxxed by a group. I won't share their name. No more advertising that they need, but by a group that decided to protest out of his home or in front of his home due to his work as a compliance officer. And in a video posted to social media, the leader of the group went through and shared his personal address, his name, and implored him and encouraged him to stop doing his work. My coworker has a wife and 2 small children and is now deeply concerned about their safety, as I imagine we all would be. I would implore you to consider this bill and its effects on not only public employees, but all Oregonians. Thank you very much.
All right, thank you very much. Tom Holt.
Chair Przansky and members of the committee, for the record, I'm Tom Holt here today on behalf of the Society of Professional Journalists. They're the working reporters. We support the direction of House Bill 3047. I'm here this morning specifically about the A5 amendment, which we oppose. The deletion of one word from the statute on page 2 of the amendment, the word personnel, would have sweeping consequences. In the 24 hours since we were able to see this amendment, we consulted with several attorneys with expertise in public records. We've gotten varying opinions about the potential impacts of this, but what is clear is that it would greatly increase the cost of public records requests and could reasonably be interpreted to require agencies to scrub any records request to make sure that there isn't employee information in it. It also would interfere with some well-known reporting that's been done in recent years, reporting around where police actually reside versus the cities that they're employed in. Or in case of some very senior officials of this state who used personal emails to conduct official business that was revealed through public records requests that would not be available under the terms of this amendment. So we oppose this amendment. We urge that this very complex issue of personnel, personal information of public employees be discussed in the interim in the appropriate forums. But this is on very short notice without much discussion, and we do not think the A5 should move forward. Thank you.
Thank you, Tom. Our next speaker is Scott Winkles.
Good morning, Chair Przansky, members of the committee. For the record, I am Scott Winkles, representing the League of Oregon Cities, appearing in support of House Bill 3047. The League is in strong support of this bill. I'm aware of instances of public municipal employees in the state being doxxed for performing their job functions. It causes them great fear, significant inconvenience, having to change phone numbers, email addresses, and social media accounts. They suffer damages, and we believe that they should have an ability to get recourse. I will address the A5 and hopefully clarify some intent. We have a court case early in the stages right now in which there is a significant difference of opinion on the interpretation of ORS 192.355 sub 3. This exempts from release residential addresses, personal cell phone number, dates of birth, personal email, among other things, if those records are contained in a personnel file. At issue in the court case is that if the personnel information exists outside of a personnel file, is the agency employer required to release it in a public records request? HB 3047 provides this private right of action if there's an improper release of personal information. If the court agrees with Portland in this case, the release of that information would be improper. If the court agrees with the district attorney and some testimony you heard earlier, that record is now a public record, which can be, there's no limitation on what can be done with that. It can be spread broadly. We believe that having this information out as a public record would limit the ability of some public employees to utilize the statute. It appears that the legislative intent has been all along to exempt this information from release, this private personal contact, in a course of a normal public records request. And we say this because there's a sub B in the statute that allows personal contact to be released with a showing that doing so is in the public's interest. If we simply strike the word personnel so that the exemption to release that personal information to all records held by the public agency, with the exception of that sub B, we believe we're simply aligning with what a lot of agencies in the state had interpreted the statute as meaning all along. And I will submit additional written testimony.
Thank you, Scott. All right, Michael, was there anyone else that signed up this morning that was not on the pre-registration list?
Not to my knowledge, Chair.
All right, we're closing the public hearing on 3047A.